I'm here. A few minutes after 2, but I'm here. My name's Elizabeth Mathern. I am coming to you live from our South Georgia office. We're gonna do immigration updates and answer your questions live. A lot of exciting news in the immigration world right now. We've got our big Immigration Lawyers Annual Conference happening. A lot of announcements usually come out during that week, so it's always an exciting week for us. In the world of detention, there's a lot of interesting news, so I'm gonna give you that. We got more guidance on motions to reopen today. We got more guidance on prosecutorial discretion earlier this week. So we're going to go through all that. We've seen movement from people being moved from Stuart to a tiny little detention center in Florida. I'll update you on that, and I'll answer any of your questions. I'm sure that people are going to have diversity lotto questions. I'm not going to be giving you any updates on the litigation. I'll do the best I can with just general questions regarding case flow, but no litigation updates today. Yeah, so feel free to ask any questions you might have, and don't hesitate to stop by the comment section and say hi. I love hearing from people. I love seeing you guys and visiting with you. So if you're just joining, my name's Elizabeth Mathern. I am with the Cook Baxter South Georgia office. I'm in Adel, Georgia, which if you don't know where that is, that's halfway between Tifton and Valdosta, right off of I-75 and a little bit from the Florida border. We're about 37 miles from the Florida line. So if you're coming and going from the beach, stop by and see us. All right. Okay, so what's going on today, June 10th, in the immigration world? First off, Irwin is still detaining people. DV 2021, I'm not really going to be giving any updates on litigation, okay? But nice to see you, Riale. I have to put on my glasses. Please feel free to post hellos where you're watching from, any questions you have, okay? All right, Riale. Usef, I'm not doing any DV updates. Okay, Daniela Stephanie, she has a question regarding change of status. All right, if someone changes status here in the US from B1 to F1, can their dependent apply for an F4? So Daniela, I think you're thinking of a scenario where somebody changes from a visitor visa to a student visa, and whether or not their dependent can apply for an F4. I don't know. That's a very interesting question. I'd like you to message me a little bit more about what's going on. You know, one of the interesting things about change of status is that these are taking a little while. That's the scenario. Yeah. I don't know, Daniela, but I'm happy to research it for you. And let's see. I bet one of our partners knows. Okay, we'll find that out for you. I know that, yeah. So it's a non-immigrant intent. So I would imagine that you maybe could do the dependent for the F4, but I know that there's some hoops you have to jump through with kids on non-immigrant visas going to school and stuff like that. So that, I don't know, maybe you're already prepared for that because you're already on a non-immigrant status. Okay, yeah, F2 is what I was thinking. I was thinking a minor, a dependent minor that would have to go to school and stuff, so you'd have to pay for school since you're on a non-immigrant visa. But maybe you're already dealing with that. I think probably one of the best answers I can give you is in this particular scenario, it's going to be very fact sensitive regarding like what ties you still have to the home country and all of that. So, and whether or not you've gone out of status at all. So it might be worth your time to do a consultation with one of the attorneys. All right, Folks who are looking for updates on diversity visa, litigation. I don't have any updates for you all at this moment. The best place to find those updates is to watch Mr. Cook's Facebook Live on Wednesdays. Okay, that's where you get all that good information. And it's right before I do mine on Thursdays. So what you can do is you can go to our Facebook page. If you haven't seen Mr. Cook's Facebook Live from Wednesday, scroll down and find that video. You can watch that. That's going to be the latest updates. The other place to find the latest updates is following Mr. Cook on Twitter. All right. And if you're not already following him on Twitter, I don't know what you're doing. If you're interested in DV litigation and you're not following Mr. Cook on Twitter, you're late to the party, because that's where all the good information is, okay? All right, so let me give you an update on, let's talk about prosecutorial discretion. So for people that have cases in immigration court, we now have a little bit of an idea on how prosecutorial discretion is going to go. So we can now submit a request for the prosecutors, which is, we call them the Office of Chief Counsel. That's the prosecutors in immigration court. We can ask them to review the case based on new guidance. And that's going to be people who, don't have significant criminal history, things like that, okay? So we can affirmatively ask for them to review the case, and the thing that you're asking for is for the removal proceedings to be dismissed, thrown out altogether. So that means you won't have to be going back to immigration court. But if you don't have an application pending with USCIS, and the only application that you're eligible for maybe is in front of the immigration court, it's an interesting decision to be made, whether or not you want your case thrown out. What I imagine is going to happen is we're going to see a lot of cases be taken off the dockets. So this is one way that the administration can figure out how to manage this backlog, right? As some of you know, we have like over 1 million case backlog in immigration court. So that means processing very, very slowly. I mean, some people have been waiting. I would say there's people who were released more than 4 years ago who still haven't been to a master calendar hearing. They just keep getting rolled out. And then with COVID, all the master calendars got reset, and we were only doing individual hearings. So it's an interesting situation. Another thing that they're doing to try to manage this backlog is Obama 2.0, a reboot of the rocket dockets, which we saw in the Obama administration. Fast track hearings. That was not a positive development under the Obama administration. I don't think that rushing due process to the disadvantage of the person trying to assert their rights is never a good idea. If the mechanism pushes the government, the strong arm of the government that has all the resources, infinite resources at their disposal to move faster, and then that helps us. That helps, things stay balanced and things move more quickly. But putting a fast track procedures on people who most likely are victims of trauma, who still haven't even sort of landed and been able to unpack maybe even why they are fleeing their home country. Sometimes people are just in crisis and trying to figure out the next step, putting one foot in front of the other. And it's really hard for an advocate to sort of help them to best unpack their case and to be able to put that on for a judge. So we will continue to watch those rocket dockets. Thankfully, Atlanta was not one of the test sites for this new approach, but I'm pretty sure South Florida is. So that's sort of in our region. We'll see how it goes. All right, so as far as detention cases, I know a lot of you don't watch our Facebook Lives for the immigration detention updates, but for those people that it matters to, it matters a lot. So if you have if you have a family member that's detained in immigration detention, then you care a lot about what's going on there. Irwin County Detention Center, the administration announced that they were going to close. Sorry, technically they announced they were withdrawing the contract, which is, I guess, we don't want to do business with them anymore, with the private prison company. But they didn't say when the current contract would end or whether when they were canceling the contract. So the news from Irwin is people are still getting sent there. There have been pretty massive COVID outbreaks in the Irwin County Detention Center recently. It is a little bit more difficult than it used to be to get in touch with clients and to get Skype set up and all. I think that's partly because maybe the people who work there, I don't know, maybe think they're not going to work there much longer. So what's the point in doing a good job? I don't know. But it's been a little bit harder to get Skype appointments and stuff with clients. And the COVID outbreak, I think, is reported yesterday or sometime early this week that like around 50 people tested positive for COVID. So it's there, it's spreading. Not good. All right, Stuart still continues to get a bunch of people, including women. A big group of people, I don't know, maybe around 100 people were transferred from Stuart to Baker. That includes men and women. Baker is about an hour and 45 minutes from our office here in Adel, so it's still like within our region. And during the Trump administration, we saw this as well, where a group from Irwin was taken down to Baker. Some of the people, which is in a different court's jurisdiction and a different ICE jurisdiction, some of those people were brought back, and some of those people were their jurisdiction was changed, their venue was changed, they were maybe transferred down to South Florida immigration detention centers. Baker is a county facility, and it is pretty crummy. I mean, all of these immigration detention facilities are bad, but I've heard really bad things about Baker. Food, recreation. I remember one client telling me that it was really, really cold in there. So I know if your loved ones have been transferred from Stuart to Baker, you're going to be really concerned about them. The good news for advocates is that it is pretty easy for us to get a phone call with our clients at Baker, and I'm not far from there. So if we needed to go down and see them for an emergency, we could. People who are suffering from medical neglect and still haven't been released should be reaching out. Should be doing written medical requests, even if they've been transferred to Baker. You know, there's always a lag whenever somebody's transferred in their commissary. So it takes a week, 2 weeks for them to get their money, to buy a calling card, whatever. So if you have a family member who's been transferred, sometimes the easiest thing to make contact is for the attorney to be able to call and set up a legal call. So that's an option. All right. Another piece of news that I wanted you all to know regarding the detention front is we've been seeing a lot of people from the border, especially women, young women. I think I've told y'all in some of our past conversations about like family separation, that maybe it was an 18-year-old daughter separated from a family group, and the rest of the family group was released, but maybe a daughter was held back, or a young couple split up. So a lot of family separation with like young adults I've seen. Also, and these people are coming straight from the border, being put under quarantine, and then going through the credible fear process. So it's all pretty fast and pretty confusing for people. What's interesting is, to me as an advocate, is that I've seen things go a little bit differently with this particular type of case recently. So these are people who have a fear of return, and when they were intercepted at the border or near the border, told immigration that they were afraid to return to their country, which puts them in the credible fear process. They then have an interview with the asylum office, and the asylum office can approve or deny whether they believe their claim and whether it's sufficient to meet the burden. If they deny it, then that can be reviewed by a judge. So usually the way it would work for release is that ICE would wait for people to be put through this process. If they had a positive determination, then they would have their case opened up where they could apply for asylum in front of an immigration judge, and ICE would parole those people if they could show that they had a blood relative, they weren't a danger to the community, etc. So usually a lot of people seeking protection don't have any criminal history. So that was pretty standard that people in that scenario would get released. But the people who got a negative finding that was affirmed by the immigration judge, that was usually no release, you're getting deported. At least in the past 6 or 7 years, that's what I've seen. Well, and it was a rare instance that somebody would get released, maybe for a medical issue or something like that. Well, now it seems that ICE appears to be taking the approach that they're releasing people in a negative credible fear that's been affirmed by an immigration judge posture. So that's really interesting. And I think it's something to watch out for. If you have family members who are in that situation, there's not technically like a release request that we can file, like a parole request or a bond request in that instance, because it's sort of a legal loophole. But we can advocate with ICE, give them proof of where you would be going or your family member would be going. So there is something that could be done on the advocacy side there. And so that's what we've been able to do for clients in that situation. And it's very interesting. So just wanted to give you guys an update on that. And let's see. Okay, we've got a few questions I see coming in. Let's see if we can take them. Okay, I might have missed it. If you have a chance to go over the American Families United Act. This, I think, is the legislation that waives the 10 and 3-year bars. Those are, it's a great piece of legislation, if that's the one I think it is. It's a great piece of legislation. I just don't have much like optimism or hope that anything that major is going to get pushed through at this point. I mean, we're just, we are in a pretty bad situation with our Congress right now, right? So for those of you who don't know, we have a very slim Democratic majority, and we'll basically have 50-50 with the vice president being a swing vote, and she is a Democrat. So, and with the filibuster, they need over 60 votes, which means 9 or 10 Republicans would need to join to get any legislation passed. Now, if they put it in part of a reconciliation package, in theory, they could pass it with without the filibuster. But we're not seeing anything happen on that front. Like, I haven't heard anything regarding reconciliation. And it seems like the Dems are just kind of frozen. Kamala Harris, our vice president, went down to Guatemala and Mexico this week, telling people that they wouldn't be admitted into the border and do not come here, and making statements that coming to the United States is illegal migration, when seeking asylum, seeking protection, is very clearly legal. Like, it's provided for in the law. So I don't know. I think it almost seems like that sort of, we're seeing the same playbook again, right? Like pandering to super conservatives to be able to say, no, 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 we don't want an open border, with the thought maybe that then they would be able to negotiate or bring conservatives to the table to discuss legislation or reform for people who are here in the country. I've just never seen that work out. I mean, I haven't been around forever, but in the short time that I have been paying attention to politics, I've never seen that really work. There's either bipartisan support for doing something or there's not. And right now it seems like both sides see more value in just sitting around than actually making anything happen. So you can look for the Democrats to basically lose power for a decade is what most people are predicting. All right, so let's see. What's the situation about Gula v. Biden? I think you're asking for litigation updates, Ani. I'm not going to be giving those today. Carolina, I see your question. I'm working really hard today. I'm going to jump off of this, finish up an appeal, and I'll give you a call. Don't worry. Don't worry. We're getting it done. All right. DV 2020. All right. You are a winner from Afghanistan. Kabul won't begin interviewing. It's an injustice. Oh, Halim, I'm so sorry. I think, yeah, this is why we have litigation pending, right? Because we're trying to get the government to freeze or save these people in your situation. It's just really, really, really unfair. I mean, you can't, I don't understand how the government could think it would be acceptable to just allow legitimate visas to go unused simply because of shutdowns, voluntary shutdowns at this point. So it's just really fundamentally unfair. So keep watching the litigation, and let's hope that there's a some sort of benefit in there for people in your situation. Are we still taking plaintiffs? Llama, there is a litigation website page that will tell you whether or not the different cases are taking plaintiffs. I'll try to find that and post it in the comments. If you Google the Cook Baxter litigation, I'm pretty sure it's on our webpage. Okay, and I don't know off the top of my head which cases are still accepting plaintiffs, but it's really clear on that webpage if you can find it. Okay, all right. So I think that's it. That's all the questions for today. And as far as updates, motions to reopen. This is a big one, and I'm going to say it real quick, and then we're going to end because I got to get back to work. Motions, the government sent out information today that they may be open to reopening cases where you might remember that the Supreme Court came out with a decision about a month or so ago that said if the notice to appear was not properly written when it was first issued, meaning it didn't have a time and a date where the person was supposed to appear, it's called a notice to appear. So if it didn't have a place and a time where the person was supposed to appear, then it was invalid. And what has happened in the past is it's been found valid. So it could cut off your time for cancellation or removal. They could cut off your rights and you not know where you're supposed to go because maybe the government, you put in a change of address, but they didn't put it in the system and you didn't get the actual notice of where you're supposed to go. So now this Supreme Court decision says needs to have had the information required within the four corners of the document that was originally created so that you had sufficient notice. All right, so if somebody has a removal order, either they went to court and took the removal order, maybe because they couldn't apply for anything. The court found that the notice to appear cut off their time, and so they weren't eligible for cancellation, or they missed court and now they're eligible for cancellation. So that notice to appear that didn't have all the information can't be used to cut off your time. So the government says that now they'll entertain motions to reopen based on and join us in those motions to reopen, which is really good news. But they're basically saying there's a finite window that they want these all to happen. So don't sleep on your rights. Act now. Basically, they're giving 6 months. I think it was November. No, that's not right. Basically, it was a 6-month, 180-day window for people to ask for these types of joint motions to reopen. So please, 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 if you had removal proceedings that are, you've got a removal order, you had a removal order, you had voluntary departure, or even your removal case is still pending, you need to have someone or yourself look at that notice to appear and see if you can benefit from the Supreme Court decision at all, because it's a really, really great opportunity. And I would say that's especially important if you have a United States citizen, children, spouses, parents, or green card holder, parent, spouse, or child. And if those, if there's any hardship, what we have to look for in cancellation removal is exceptional and extremely unusual hardship. Now that's really a legal analysis. So it's important for, there's got to be something that's different from what people usually face when a parent is removed from the United States. It's a high burden, but sometimes it's also a cumulative analysis. So sometimes when we put all the factors together of what's going on with everybody in the little family, then we meet that burden. So it's really, really important that if this applies to you, you should definitely get in touch with somebody, do a consultation with us. If you would like to do a consult with me, feel free to give our office a call. This is my number here at the Adel office, 229-472-5775. Please feel free to give me a call, schedule a consultation. Well, that's our 30 minutes. I got a ton of work to do, so I'm going to get back to it. Thank you so much for everybody who joined. It was nice seeing you. And thank you for asking questions and being a part of our Facebook Live today. Take care, everybody. Bye. I'll see you next week.